And folks, welcome to the Law and Crime Network. I'm Michel Bryant. Joining me here in the studio, Brad Micklin. And hey, it's Friday. Congratulations, you made it this far. And we have made it quite some distance too in the main case we're following here on the network, Florida versus Jimmy Rodgers. This is the hitman case in which he and a couple of other guys, including the victim's husband, have been accused of orchestrating and carrying out a bludgeoning death to this young lady, Dr. Teresa Sievers, 46 years old at the time of her murder. What we're hearing is a pretty darn well briefed attempt to convince this court to just say, hey, prosecution's evidence not enough, even if looked at in the most favorable light to the prosecution, not enough on its face to prove a prima facie case against Jimmy Rodgers. So, Brad Micklin here, trial attorney. Is this going to win the day?
No. Then they rarely do. I mean, you do it sometimes if there's just a gross error in the trial, but usually it's just a matter, of course, you don't lose anything by trying it, and you kind of hope for the best. But it's
yeah,
not
and you make a record.
Yeah, it's not going to make any difference.
So, Ecleynne is with us too. From Micklin to Ecleynne. We're going to Ecleynne, Mercy. You're in Atlanta there. You know, the states, I know you're neighboring states, but you have a similar process there at the end of the evidence by the state, right?
In which you just state that the state did not carry their burden. Everybody does it. You have to do it. You try your best. And you throw all the cards out there and you hope one sticks, and it usually doesn't, and you go on from there.
Yeah, directed verdict in California too. Looks like they're back at it in court. Let's go in. So what we have here is a very elaborate attempt to convince the court, again, that this case should not go forward as to this defendant, Jimmy Rodgers. I want to ask, I got a number of experts here, which is always very helpful for me. Daryl, Washington attorney, is joining us. And one thing I picked up in this argument is the distinction this attorney is trying to make between what a principal is and what an accessory is, suggesting Jimmy Rodgers was merely that, an accessory. How important is it to make that distinction at this point?
I think it's very important to make that distinction, because here, just listening to the what he's using in his argument, he's basically stating that he was not apprised of the initial plan to commit this murder. He was merely just an accessory. He didn't have any involvements. He did not even know how it was going to take place. So I think the argument is that it's going to be very difficult to state that he was a principal and merely just an accessory to this crime.
Yeah, it's not a bad move. Ecleynne, Mercy, you know, we know that Jimmy Rodgers brought his cell phone. He went like he was going on vacation. He took photos there. He got souvenirs. So I would use that, if I'm defending him, to argue that that's because he had no clue. He had no idea what was going on. What do you think?
Yeah. Absolutely. And for a conspiracy, you need a meeting of the minds. And what they're actually arguing is that there were no meeting of the minds, that it was like really real quick. When the co-defendant testified, he said that it was like really quick, like it wasn't as planned. So there weren't really a meeting of the minds. So I think that defense's argument has a bit of legs on it. So, I mean, it could push some case law, because, again, for conspiracy, you have to have a plan. It has to be a meeting of the minds, and we really don't see that. So I can see what the defense is actually trying to argue.
Yeah, it's a good argument. And Brad Micklin, to take off on that, the conspiracy concept is if you're in for a penny, you're in for a pound, as they used to say in England. So, you know, if you're not part of the whole mix, can't you just walk?
I don't know. In this case, no. Maybe in certain cases, if you could show that you really had nothing to do before, during, or after it, but I don't think that's going to be the case here. I mean, it's compelling when you sit and listen to one side argue it, but I don't think there's any chance that the totality of the circumstances aren't going to suggest that he knew he was there to commit some crime, some heinous crime, and that didn't do anything during or after to prevent it.
Yeah, and if you find there is that agreement, if you prove that agreement, then you really are stuck for the ultimate crime, even if it unfolds differently than you might have originally expected. There must be a meteor shower or something there breaking up some of the feed from the Florida courtroom there in the Jimmy Rodgers case. This is the prosecution, of course, rebutting the defense motion for acquittal, basically saying, hey, the prima facie elements have been met here, Your Honor. Ecleynne, Mercy, I know you paid a lot of attention in class. We're going to go to the Law and Crime classroom right now with you, Professor. What is a prima facie case?
A prima facie case is based on the facts. That based on the facts, it is clear cut that this is what happened. We don't need, so direct evidence is that I've seen it. We have testimony, we have phone calls, we saw the blood, somebody testified to actually being there. Circumstantial evidence is basically, we see it's implied. It's implied that what happened, the jury has to use a little bit of imagination. So prima facie case is based on the facts, like we have direct evidence that this happened. And in this case, we have direct evidence because somebody testified that there was a hammer in his hand in which he bludgeoned this woman to death. So it is a clear-cut case. I think right now they're focused on the legal argument of conspiracy and whether there was enough to hold him liable for the conspiracy of the murder. So that's my explanation of prima facie case.
Okay, thank you, Professor. Yes, and remember, that's a question of law, so that's for the judge. If it were a question of fact, that's for the jury. Remember Max Headroom? Remember those, look it up if you don't remember Max Headroom. That's how I kind of feel at the moment. So again, some technical issues going on in the courtroom there. The state has rested, some post-rest motions. What we don't know, what we're trying to find out, is whether or not the defense is actually going to put on some sort of case. Brad Micklin is here with me. Not unusual that they don't, but in this case, where there seems to be so much overwhelming evidence pointing to Jimmy Rodgers sitting there, what would you expect?
From Sievers?
Yeah.
I expect them to put on some kind of defense. I would never, as a defense attorney, sit there and just hope that, one, they think Rodgers did it, and that they're not worried about their cooperating witness who tied him into it. So he's got to do something. He probably won't testify, but he's definitely going to put on a case.
Yeah, that might be expecting a bit too much, but we're getting used to that these days. Okay, let's go back into court. Well, so again, itemizing the things that should convince this court this case has got to move forward. I'm pretty sure that's what's going to happen. Daryl Washington, attorney with us still. I think we've kind of gone through all the details on this, so let me ask you a question more procedural and practical than anything else. We see counsel there taking documents to the court. These are cases she's looked at and briefed. I don't think that's going to continue for much longer. I think pretty soon people are going to, the attorney's just going to say, Judge, I'm texting you the site, I'm sending this to you by phone. Is that a good or bad thing? Because it's really sort of a tradition in presenting a case where you've researched something and you present it to the court. I don't know. What do you think about the new wave that I believe is coming?
I mean, I think judges, they're going to remain old school with it. It's just a technique that we have used to make the judge believe that we are really prepared and we know what we're talking about. I think giving the judge the cases saves time, and it allows her to go right to the law that enables her to make the decision that needs to be made. But I think the attorney is really arguing the point really well. But listen, let's think about this. It's going to be very difficult to convince a jury that there was not a conspiracy, that these guys did not talk about what they were going to do. It's just going to be very tough.
Yeah, and I think we have to remember that there is no IQ requirement for conspiracy, because if that were the case, maybe you got an argument then. I see us going forward, stuff like this. Judge, let me tweet you the site for that case. I know it's going that way, and it just kind of bothers me. Okay, we're going to come back. This is the Law and Crime Network. More out of that Florida case. Jimmy Rodgers, the state has rested.